ascertain whether prospective jurors are telling them the truth or not. But there are also instances, and Supreme Court has ruled on this, and a number of the justices have written very interesting accounts of this. Particularly, if you want a recommendation, I would recommend Justice Brennan's opinion in the Nebraska Press Association case. He wrote a concurrence that I think really lays out why we can't do that and why we shouldn't do that. For example, in a case where there's this convicted sex offender in Florida who has been arrested, confessed to committing a horrific crime on a little girl. And it turns out that it's possible that his confession will get thrown out because at one point he asked for a lawyer. He said, maybe I should get a lawyer. They paused. They started questioning him again later. Can't do that. And as a result, that confession may get thrown out, and there is a chance that the charges could get dropped against him. Does the community not have a right to know that? This wasn't a coerced confession. No one's suggesting that he was sitting there feeling, you can argue that any time you mention the word lawyer that somehow it's then coerced. But as a practical matter, there's no argument that it was a coerced confession. And I think the community has a right to know that, to know what is really going on as opposed to the specific constraints that the legal system imposes. The reason that there are rules in a courtroom is because the government has the power. The government has the power to take away someone's freedom. That is an enormous power. And as a result, we try and stack the deck against them. Now, you can argue that the deck doesn't end up getting stacked against them anyway. But the reason we have a standard of proof beyond a reasonable doubt basically says the government has this enormous power, and if they're going to take away someone's freedom, they better darn well be able to prove it. We don't have that power in the media. I don't buy the argument that media pressure somehow leads to a particular conclusion. If that's the case, and Tom's right that the media was so awful and so horrible to Michael Jackson, these jurors are saints, that they were somehow able to avoid the insidious media coverage. And anytime these celebrities are found not guilty, O.J. Simpson, the media coverage was all so unfair against O.J. He was found not guilty. Robert Blake was found not guilty. It just doesn't prove to be true. So I'm sure you all have probably more questions than would rather ask questions than hear me go on and on. So I will just say thank you, and that I really mean what I say about Tom and Martha. I did see try a part of a case a long time ago, but I can't say that I know, because I also watched Tom in the Robert Blake case, where I think he was single-handedly responsible for getting some of the charges dropped against Blake in the preliminary part of the case, which he's right was televised. And again, I remember he came on my show at that time, and he said, well, it's the evidence and this and that. It was really the lawyering. And so I give him enormous credit for that. And I always love having Martha on as a guest on my program. And thank you, Professor, for inviting me.
Thank you, Dan. The final presentation before we to the questions comes from Martha Cokeley, let me also say for this record so it's clear that I did invite the prosecutors in the Michael Jackson case twice, and both times they refused. The second time, they adamantly refused to come to be on the panel with Tom Mesereau. And we also invited Judge Melville, who thought about it and very much was interested in coming, but decided since there's still some remaining legal issues in the case, he would not come in, but maybe coming later. But Martha Cokeley has the other side. Many of the students here practicing also will be prosecutors. And here's where race and justice also intertwine. Here is a very impressionable and compelling white defendant, a foreign defendant, and where the community, the press loved Louise Woodward. It wasn't that she didn't do it. It was the view that she couldn't have done it. Look at her. And what challenges that place for a prosecutor to try to present your evidence when the defendant in this case is someone who looks like everyone's daughter or granddaughter, and where, in this case, while people were looking at Louise Woodward, Martha Cokeley was looking at the forensic evidence and trying to prove that she did do it, even if you didn't believe that she could have done it. And to share some reflections on that case, Race and Justice, and in dealing with the media, please welcome Middlesex District Attorney Martha Cokeley.
Thank you, Professor. And I'm going to be really quick because I'm sort of the country cousin here and I want to leave time for questions for our visiting celebrities. A couple of things just about media and then about race. I grew up watching a lot of Perry Mason, and I have to tell you it's probably one of the reasons I became a trial lawyer and a prosecutor. You know, we figured we needed better prosecutors after Hamilton Berger lost all those cases. I also had the opportunity in the summer I was studying for the bar to watch Ted Bundy defend himself in Florida, and I was fascinated. I was totally hooked on court TV. That was court TV in the good old days before all the talking heads came in, but you got mostly uncensored, real trial testimony, and it was fascinating to watch. However, I will say this, as someone who's tried a lot of cases in Massachusetts with television cameras in the courtroom, Massachusetts followed Florida, allowing TVs in, and that's why you see a lot of Massachusetts cases. My observations are that if you're a really good trial lawyer, you forget about that. You want to make sure your jury pool has not been infected by the media, but after that, you focus on what's going on in the courtroom, and you don't pay attention to what Dan Abrams is saying about your case or anybody else, because it doesn't matter. Particularly true in the Woodward case, and there's a great documentary about folks who have odd occupations. One of the guys who was interviewed for this documentary was a lion tamer, and when asked about how he felt about the 50,000 people in the stands when he got in with his chair, he said, "You know what, I only think about the lion." And that's exactly what a good trial lawyer does. I'm sure Tom would agree that when you're in the courtroom, the lion is the judge, the lion is the jury. You don't worry about the other stuff because what those 12 people are thinking is what matters. And that generally proves to be true. I think jurors do look at evidence, they do look at what they hear, and they try and be fair. And we've lost cases and we've won cases, and I can't think of too many that we've won that we shouldn't have. I think of some that we lost, and I know why we did. And I actually have a lot of confidence in what jurors do. They're not perfect, they're not 100%, but they basically do a pretty good job most of the time. In that particular case, in the Woodward case, not only was this issue of could this 18-year-old possibly have done it, but don't forget, part of the dream team from O.J. Simpson had come to Massachusetts. Barry Scheck came on board. He'd just gotten that big acquittal. His biggest concern was whether jurors would hold it against him somehow in Massachusetts. He was quite disappointed to learn a lot of people didn't know who he was. But he did a fabulous job in that case. But I said to him at one stage, "Barry, you just don't understand the medical evidence. You don't understand the forensics," because he's a brilliant lawyer. He's done tremendous work around DNA, and he's done a lot for people who have been wrongly convicted. We've worked with him on those cases in Massachusetts. So I have a lot of respect for him. I think of him as a friend and a colleague. But he had not done a child abuse case. And the simple fact was that whether it was Louise Woodward or anybody else, the jurors said, we looked at the medical testimony. The baby had a cracked skull, severe bleeding, retinal hemorrhaging, and a constellation of injuries that could have only been caused by intentional inflicted injury. The jurors listened to that. I'm not sure Judge Zobel did. He was busy writing up on the desk while the experts were testifying. And the jurors, I think we had a chance to meet with them afterwards, said they listened to the medical testimony. So that was comforting to hear that. A couple of comments on race. Let me just, I talk a lot about high-profile cases because we've had so many of them. And I note with some irony that it was only after what I call the couple of summers of young blonde girls who were abducted, many were found murdered, some in California, some in Massachusetts, that we had the national push for the Amber Alert. Great idea, right? Let's make sure that we respond when that happens. But my point is this, you know, most child abuse occurs from people they know, homes they live in, friends, family. It's not, you know, it's obviously horrible when someone is abducted by a stranger, but it was also true that it was those cute white blonde girls that got everybody's attention. And there are children all over this country who are abducted by strangers, who are mistreated by their parents, family, friends, who don't have the cute faces and the blonde curls to get attention. And so we spend a lot of money on a system because That's what people want to see, and that's unfortunate. Let me make a second point. We have, and we are still investigating what we believe to be a murder case in this county when there were 3 young women who had disappeared and whose bodies were found, now skeletons, in Hudson and in Marlboro in our county. Denelia Torres, Carmen Rudy, and Betsy Montalvo had disappeared off the streets of Worcester. They were substance abusers. Many of them had turned to the street to support themselves. In one case, the family didn't even know they were missing. And as horrified as I am by those women's lives, by their deaths, I'm more horrified by their lives because they fell off track. People didn't know where they were missing, and we have victims like that all over this country every single day, and they don't get a fair shake when they're alive and sometimes when they're murdered. And the third thing I just want to mention is really to respond to Tom's point, and it raises ethical issues, I think. You know, defendants who feel they will be prejudiced, a jury will be prejudiced against them because of race or ethnic or some other reason, have that opportunity to play the race card. Well, what happens when the defendant decides he's going to play the race card against the victim? Different story, isn't it? Case on appeal right out of this district. A Harvard graduate student, white graduate student, who he claims was attacked by a young Hispanic man while he was walking home one night from a local watering hole. All the race cards were being played on this. This victim came from a tough family, had a criminal record. It must have been self-defense. Case went to trial, emotions were high. He was convicted of manslaughter. The case is on appeal. But it actually brought up issues about what can a defendant do in attacking the victim. And you know who's going to suffer from that kind of rulings. It's going to be poor people, it's going to be minorities, it's going to be African Americans, it's going to be Hispanics. Because we all have these unconscious prejudices. So as we look at these issues about social justice and race and media coverage of this, it's important not only to look at does the defendant get a fair trial, but it's also equally important to look at does the victim get a fair trial. And that's going to depend on you guys, next generation, to make sure that we do it fairly for both sides. Thank you.
Thank you, Martha. We'll take questions now from the panel. There are 2 microphones back there. If you want to get a question, and have each of our panelists turn their mics when I think Dan's is off. It's on now? Good. Yeah. And we'll take the first question right here to the right. Yes, sir.
I'll direct this question to Tom Mesereau. This is something that is kind of delicate, and I can understand if you want to skirt the question. But in general terms, a lawyer of your caliber would charge what kind of an hourly rate when they're not doing pro bono work? Not you personally, but, you know, people of your level, let's say.
It really depends on the case.
Well, a range.
It could be a flat fee, and not a terribly large one at that, if it's a case I want for a particular reason. It could be a very, very high fee. If it's someone who has the money and it involves a lot of forensic work. So it's really hard to answer the question. I can't. It's really goes, I mean, I've taken cases from no money to a lot of money. It really depends on the case.
Heather?
This question is also directed at Mr. Mesereau. While you were speaking, you really brought up your, I guess, very diligent defense of individuals. I'm going to go to this. I really respect that, and the microphone doesn't respect me.
He's going to turn it down. Can we turn it down? Okay, go ahead.
Okay. Can you hear me?
Yep.
Yes.
Okay. I really respect your diligent defense of individuals, but one thing that was a little bit troubling to me was that in that defense, it seems as though, I guess, the overarching needs of the community may tend to suffer. You said you didn't want Jesse Jackson there, you didn't want Al Sharpton there. My question is, when can you, if you can, strike a balance between uplifting a community in general and maintaining that diligent defense of your client? Or is that better saved for appeal?
Well, let me ask you, do you mind if I ask you a question?
Go ahead.
Would the black community have been better off if Jesse and Al had been there and Michael had been convicted?
Well, I don't pretend to speak for the black community.
But you know what I'm saying. I mean, what I'm saying is this. I think, first of all, as I said, my primary obligation was to Michael Jackson and to no one else. I really mean that. I was at a judicial conference recently at the University of Nevada in Reno with judges and media people, and some media people were really attacking me for supporting the gag order and supporting sealing orders where pleadings were sealed. And I looked at one person and I said, with all due respect, my job is not to vindicate the First Amendment. My job is to save my client's life in the case. And I really believe that was my primary obligation here. But